Welcome. Funny, everyone sits like they do at church, to the back and to the sides. You can move forward if you'd like. I'd like to welcome you here to the Board of Registrars for the purpose of considering the objections filed by Mr. Timothy Toomey in complaints filed with the Town Clerk's Office and the Board of Registrars on November 9th and November 10th. I welcome you all here this morning, but I do remind you that this is not a public hearing. It's public in that you're invited to attend the hearing and watch the proceedings, but we do not anticipate asking for public input. And so keep that in mind, and the constable sitting in the back to enforce that ruling. Mr. Toomey will be able to speak, but we're not looking for a lot of other input. I would like to start by reading the complaints that we received. On November 9th, Town of Raleigh, Board of Registrars, Susan G. Hazen, Town Clerk, 139 Main Street, Raleigh, Mass. Recall petition objection, to whom it may concern. I, Timothy Toomey, hereby give notice pursuant to notice requirements of GL Chapter 55B, Section 7, and 950 Code Mass Reg 59.00. The letter filed by Mary Ann Lavassa and signatures on October 5, 2015. 1. The letter filed by Ms. Lavassa filed on October 5, 2015 is not an affidavit. 2. The affidavit was never made by affiant under the oath or affirmation administered by a person authorized to do so by law. 3. The signatures filed on October 5, 2015 with the Town of Raleigh Clerk's Office were never properly submitted to the Town of Raleigh Board of Registrars for certification. Respectfully, Timothy Toomey, 355 Central Street, Raleigh, Mass. And on November 10th, Town of Raleigh Board of Registrars, Susan G. Hazen, Town Clerk, 139 Main Street, Raleigh, Mass. Petition to recall Water Commissioner Timothy Toomey, to whom it may concern. I, Timothy Toomey, hereby give notice for the violations of GL Chapter 55B, Section 7, 950 Code Mass Reg 59.00, and the Town of Raleigh Chapter 637 Commonwealth of Massachusetts 1989 Act. The following objections. 1. That the signatures on the recall petitions were suspect in that many of the signatures are in the same handwriting as the other signatures and therefore cannot be genuine. And 2. That the recall petitions were never submitted to the board for certification and that the town clerk acted unilaterally to certify these signatures. 3. The letter filed by Ms. Lavassa filed on October 5th is not an affidavit. 4. The affidavit was never made by an affiant under an oath or affirmation administered by a person authorized to do so by law. And 5. The signatures filed since October 5, 2015 with the Town of Raleigh Clerk's Office were never properly submitted to the Town of Raleigh Board of Registrars for certification. I demand that the Board of Registrars refuse to certify on these petitions submitted by Mary Ann Lavassa, and if certification has already taken place, that is, it is immediately rescinded. The recall petition fails to meet the requirements of the Act and violates Mr. Toomey's rights to due process under the Constitution of the Commonwealth of Massachusetts and the United States of America. As selectman, I believe strict compliance with the recall law is in the best interest of the Town of Raleigh. Respectfully, Timothy Toomey, 355 Central Street, Raleigh, Mass. Everyone heard and understand the complaint? The registrars have copies of the complaints in their hands. Where should we start?
Madam Chair, can I suggest that you invite Mr. Toomey to speak and to present any additional evidence that he may want to?
And this is Mr. Tom Mullen, Town Council, and on Mr. Mullen's advice, yes, we would love to recognize Mr. Toomey. Would you like to speak, Tim? Can you come up to the lectern to my left?
Well, I'd like to make some comments on this. First of all, I'm kind of appalled that this got off the ground. The elephant got let out of the cage, and this elephant's running around all around town, stomping on me about things that aren't even true. This thing started off with somebody Mo Lavasser bringing in a petition with a letter, and I'd like to read her letter to the record. Susan Hazen, Raleigh Town Clerk, Town Hall, Raleigh, Mass. Petition to recall Water Board Commissioner member Timothy Toomey. This is dated October 5th, 2015. Dear Ms. Hazen, during the week of Sunday, September 27, 2015 through Saturday, October 4th, 2015, I obtained necessary 100 signatures to begin the recall process on Water Board member Timothy Toomey. Please accept this as official petition. Sincerely, Mary Ann Lavasser. Now, this is obviously a letter that went along with the petition, and the petition had 1, 2, 3, 4, 5 bullet items on it that are not true. The initial effort was the ball was started to roll when we had a meeting here, or a hearing, back in June, and one of the selectmen didn't like the fact that I became chairman of the board of water commissioners. And he stormed out of here saying that he was going to call a recall on the board, okay? With that in mind, that started things going. Ms. Lavasser initially stated that she was going to recall both Stuart Dalzell and myself. And then it's obvious to me that this thing went down to she went right strictly after me with actual malice to put this thing forward, and it's kind of a shame that this thing happened based on the conditions that she put on the initial and also the subsequent the grounds for recall. Willfully ignored legal counsel advice, the town of Raleigh Attorney Joe Fair. I mean, would you like to read these, Susan, into the record? And where they came from?
I do not have Joe Fair's decision in front of me. Is that
Okay, so you didn't have any facts when you took this thing in? Okay. Private investigator was hired for $5,000. I didn't hire a private investigator. I hired a lawyer to do an investigation. This is an error. And this thing went out on the street, and everybody in town, not only the 1,300 people that were stupid enough to sign this thing, everybody has got this flavor that I've done a lot of things that are legal, and I acted as a board member during all this information that was passed out. We did have executive sessions. It was never deemed illegal. So this elephant was let out of the bag here, walking all over town and all over me. I think it really is something that's a real detriment to me personally. My claim is that this petition is flawed because it wasn't following the bylaws. The bylaws specifically state that this has got to have an affidavit with it. And so these allegations went on to a petition, and there was no swearing that was true by anybody, and that was required with our bylaws to get this petition off the ground. This is not right. And also, I might add that in the process of certifying the signatures, there's a lot of signatures in there that are what I would consider an error, because the signatures are obviously signed by, in the presence of the person that put forward this petition, that people were signing on behalf of somebody else. So these signatures are very important to have the affidavit signed, or an affidavit to go along with it, so that this kind of nonsense doesn't happen. So somebody's accountable. So there's no accountability here from not only the town, but the people that put this thing forward. So I'm respectfully requesting that you just take this and then put it in the wastebasket. This is not right. This is against my rights. I'm a public official here in town, and I don't deserve to be treated like this, especially with what I see that's going on downtown here. So, let's see if there's anything else I'd like to add. So basically, there is an affidavit problem with this, and there's also the fact that the signatures weren't certified on the initial 100 signature thing to get this whole thing off the ground. So everything that follows that is not proper. This, the way this thing is designed to be is that people have to be accountable before it goes forward. And the Registrar's Office is the branch in this town government that makes sure that this doesn't happen. So now we have a situation now that you have an elected official that, everybody in town thinks he's doing illegal things, and there's no particular charges on it. It's not like I got arrested for robbing a bank and there's a charge here. I'm in the papers and everything. There's nothing. There's nothing to substantiate that initial petition that went out. And I really think that the registrars have not assured that this thing was done properly. And so this thing is, as far as I'm concerned, and I'm very upset about it, that it got this far. And I'm not going to take it. I'm not going to take it. So I would encourage the town to correct this mistake by either allowing them to do it again properly, or in throwing this thing out, or not doing it at all. I don't see that there's a reason why this thing has to go forward. It initially started with, a threat from a selectman. And so I'm not going to put up with this. So that's my statement. Is there any questions that you'd like to ask me?
Do you have questions for him?
I don't.
No? I would like to point out, although I sympathize with what you're saying, it's not the responsibility of us here at this hearing or the Board of Registrars in general to determine your guilt or innocence. That's just not part of what we do. Our responsibilities are simply to certify those signatures. It's part of the democratic process that a recall petition can be brought forth. It's not our position to have to decide whether it's appropriate or not. So that is evidently a question for another forum, not for this one. It doesn't really matter what the reasons are. The bylaw the act very specifically says there has to be reasons listed on the affidavit. I have nothing to do with those reasons. They did not ask me my opinions what the reasons should be, how many bullets it should be, 1 or 5. It's simply what came to me, and we wrote it down verbatim from their original sheet. So we can't address that. I understand your indignation, but we can't address that at all. I would like to read for the public that's sitting there. Basically, all of this comes from Section 2 of the Act providing for recall elections in the town of Raleigh, accepted in 1989. And the first sentence reads, any 100 registered voters of the town of Raleigh may file with the town clerk an affidavit containing the name of the officer sought to be recalled, a statement of the grounds for recall. All of these complaints have to do with that first sentence. Would you agree, Mr. Toomey?
I don't agree that this meets the criteria for an affidavit.
I agree. I understand that
Okay.
you're complaining about.
Okay.
That is one within your complaint. But just for the audience, it's basically all about that first sentence. This is what's happened, is that a citizen created an affidavit under review of looking at this act that is online, in paper, public record, and collected the signatures of 100 registered voters, and then submitted it to my office. We are calling that affidavit number 1, and Mr. Toomey just read the accompanying letter to that, which was submitted to me on October 5th. Correct? Anything else?
I'd like to comment again, if I may. That an affidavit, it's a statement that they sign something or submit something under the pains and penalties of perjury, and they're truthful and everything else. This is not truthful. So when she came in and submitted this, you should have given her a statement saying that she signs under the pains and penalties of perjury, that she's doing a truthful statement. So I understand that the registrars don't want to certify whether something's true or not, but somebody coming in should, that's the reason for the affidavit, to have somebody be on board or on the block, so to speak, to be responsible for what they're putting forward. And they're not. This was not an affidavit situation. It's a letter.
You want to speak to that?
Madam Chair, let me address this because this is one of the 5 objections set forth in the November 10th objection letter. And that has to do with whether the process involves a proper affidavit or not. I would agree that the material that was submitted to your office on October 5 does not purport to be an affidavit, and there is nothing there that is signed under the pains and penalties of perjury. I understand that since then, that deficiency has been cured, and a new petition styled as an affidavit and signed under the pains and penalties of perjury has been submitted to your office, and that you have certified at least 100 signatures on it. And in particular, that affidavit reads, "The undersigned hereby verify under the pains and penalties of perjury that they seek the recall of Timothy Toomey, chairman of the Rowley Water Board, on the following grounds." And then the grounds that Toomey read earlier are all stated. And then it says, "Signed under the pains and penalties of perjury this blank day of November 2015. There's nothing in the law that says that a failure initially to style the 100-person petition as an affidavit cannot later be cured. And I strongly believe that if this matter were to go to a Superior Court judge, he would not throw it all out because of that technical and later cured deficiency. As for whether, and this goes to another one of the objections, it was necessary for the signatures to be signed under an oath or affirmation administered by a person authorized to do so by law, that would mean that the objection is that these are not notarized signatures. There is, however, no requirement of notarization because under Chapter 268, Section 1A, the legislature has provided, quote, "No written statement required by law shall be required to be verified by oath or affirmation before a magistrate if it contains or is verified by a written declaration that it is made under the pains and penalties of perjury." So since, as I read earlier, the curative affidavit does purport to be signed under the pains and penalties of perjury, I don't think that objection number 4 in the November 10th letter has any validity. Let me go on to the other objections. Objection 1 is that the signatures are in the same handwriting and therefore cannot be genuine. I represent a number of cities and towns, and I always advise the Board of Registrars not to attempt to be or to pretend to be experts in handwriting analysis. I understand that the Secretary of State's office in Boston urges the same. I don't believe that you have any evidence before you that any of the signatures are suspect. There has been no handwriting analysis that has been offered here. So my suggestion is that in this and in all certification questions, you be agnostic on the question of whether two or more signatures are suspiciously similar. Another objection, number 2, is that the recall petitions were never submitted to the board for certification and that the town clerk acted unilaterally to certify the signatures. Well, under 950 CMR section 5502, it says, quote, "The registrars may authorize the office employees of the city or town clerk's office, including the city or town clerk, to perform all of the actions required by 950 CMR 55.02 and by General Laws Chapter 53, Section 7. This authorization may be accomplished by, among other things, a vote of the Board of Registrars." I invite correction if I'm wrong, but I understand that it is this board's invariable practice, at least in the last few years, to have all certifications done by the town clerk, and that certification then is shown by a stamp of the signatures of a majority of the Board of Registrars. So I don't think that there is any validity to that objection. Number 3 says the letter filed by Ms. Lavasser, filed on October 5, 2015, is not an affidavit. I see this as basically a restatement of an earlier objection that I've already discussed. It's true the October 5 document is not an affidavit. That deficiency, in my view, has been cured. And finally, number 5, the signatures filed since October 5, 2015 with the Rowley Clerk's Office were never properly submitted to Town of Rowley Board of Registrars for certification. I again see that as duplicative of the earlier objection, and since it is this board's policy to have all certifications done by the town clerk, I don't see that that has any merit either.
With regard to number 5, we will stipulate that the first affidavit number 1, well, first of all, let me step to the top. In the view of the Board of Registrars, who has been doing this for a long time, Gordon, I think, is the newest registrar on the board, and he's probably been doing it for 10 years now. Isn't that awful? I lost my train of thought. I get it. Hello, Gordon.
Certification.
Isn't that awful? That prior to 1996, the Board of Registrars played probably a more active role certifying the signatures, as Millie and Barbara could probably attest to, in that it was done on a paper voter list, literal paper voter list, which is now 200 pages long. Because of the nature of the recall, I had to certify this affidavit portion, the 100 signature portion, on a paper voter list. And it's a fun event with 200 papers just floating around in front of you, and every one you certify. We did a petition for Jim Toomey, we did a petition for Stu Dalzell. I did want to make that clear. They did collect signatures for the recall for Stu Dalzell, and when the time came, they elected not to take petition papers out for Mr. Dalzell. They didn't share with me their reasoning, but I'm thinking because his term is going to be up in May of this year anyways. That's just my opinion. And then, of course, we did a second affidavit from Mr. Toomey. So this one voter list now has 3 different certifications on it in multicolors. It's a very exciting event. But it's very time-consuming to do it by paper, and for that reason, the Board of Registrars could sit there and turn pages and do them. In 1996, the state came up with the VRIS system, which is a computerized system. It's a wonderful system, and you put in the name, and it says it tells you their address. They must be there at that address, and immediately it shows that they do or do not live at the address you have on the list. It tells you whether they've signed before. That's the best thing, is that if you've already put their name in, it comes up with they've already signed. So you can't get someone signing numerous times, and that is very beneficial. But it's also technical. It's a computer program that has to be done right. It's nothing that we can make any changes on. It's a state system. You have to learn how to use the state system. And for that reason, the Board of Registrars have had less input. I have an office. There's only so much space. I can't have 3 extra people in the office at any one time, and it's just for ease of handling. It's generally been the town clerk that does the certifying. Some of it is because it really has to be done right, and you can't have someone who thinks they know how to put it through the system playing with it. It has to be done right. It's important stuff. I understand it's important stuff, and it has to be done right. And number 5, the signatures were not properly submitted. I will take the hit for that. If the registrars look at affidavit number 5, the very back page, I neglected for a sheer senior moment, I have no idea why, to stamp it with the Board of Registrars stamp. I have a rubber stamp that has all 4 of our signatures. And every petition I do for the state, and we are right now into the state petition season, there are 19 petitions out there that is coming towards me between November 18th and November 30th. And they all have to be stamped, and I don't have an excuse. It's not like I did it on purpose. I just neglected to stamp that, and so I will take that hit. It does say the word Board of Registrars, but the point I was going to make at the beginning, which has finally come to me, and I appreciate it, for the purpose of the Board of Registrars, who are citizens, not lawyers. I am not a lawyer. They are not lawyers. They're citizens who are volunteering their time. We feel that the first affidavit that we accepted is in the spirit of the act and the will of the people. It is upsetting to me to find out afterwards that it did not comply with the specific rules of being an affidavit, but I really didn't have an awareness. It doesn't speak to that in the bylaw. It does use the word affidavit, but it doesn't say must contain these 2 items. And so in our best opinion, it seemed to comply with what the bylaw asked. The bylaw simply asked for any 100 registered voters, the town may file with the town clerk an affidavit containing the name of the officer sought to be recalled and a statement for the grounds of recall. It did contain that. And that's our defense for accepting that first affidavit that is now being challenged. Yeah, anything to add to that?
Just one more point, which is that I have looked at the petition form that was signed by the 25% of the registered voters, and it's clear from that form that no one was in any way misled by the failure of the October 5 filing to contain the word affidavit or the magic words signed under the pains and penalties of perjury. That's another reason why I think that the curative affidavit that was later filed would be upheld as adequate by any reviewing court.
So I will say, under advice of town council, we gave Ms. Lavassa the option of collecting 100 signatures again. And probably everyone in this room got that phone call. And this time, they collected 214 signatures. It was due at noontime yesterday. And so after noon yesterday, I got out the paper voter list again and spent the day shuffling through those pages, and 214 signatures did certify on the second affidavit, which does contain the word affidavit at the top. We, the undersigned, hereby verify under the pains and penalties of perjury that they seek the recall of Timothy Toomey, chairman of the Rowley Water Board, on the following grounds. And Tim read 5 grounds. And at the bottom of that 5 bulleted section, signed under the pains and penalties of perjury on this particular one I have in front of me on the 12th day of November 2015. They all, most of them say the 11th, but they all have a date on it. Everyone has a date.
May I have a few more minutes
Yes.
here? Yes. Okay. So as I understand it, you went out and you did another...
I did not do anything.
I mean, somebody went out and got another 100 signatures between the time I filed this objection? Mm-hmm. Okay. So are you considering the signatures for the subsequent 12 or 1,300 that are valid now?
Well, as I said to you earlier in the week, I mean, if step 1 is flawed, then step 2 doesn't exist. But
Right.
We feel, the Board of Registrars, I believe at this point, feel that the wishes of 1,303 people need to be addressed. And this office is trying to do anything it can do to make sure we're not throwing out 1,303 signatures. Mm-hmm. If at all possible. My statement a minute ago was that to our thoughts, the original affidavit fulfilled what needed to be done. The word affidavit became an issue, had very specific legal technicalities involved that unfortunately I wasn't aware of, but I am now. And we accepted it because we felt it complied with the recall bylaw and that it expressed the will of 100 registered voters as first sentence of Section 2.
May I see that right now?
Tell me what, the second affidavit?
Yeah, let's look at the affidavit.
You can look at the original. Oh, no, that's your copy, that's fine.
It's just a copy. It's just a copy. It's just my copy out of my notebook. Well, Tim is looking at that. I will agree with Mr. Mullen. I go to conferences every year. I've been town clerk for 15 years. I've gone to at least one conference a year, sometimes 3 conferences a year. Invariably, the Secretary of State's office is there. That's why we have these conferences, to keep us up with the laws. And Michelle Tassinari, who's Chief Legal Advisor for the Elections Division, is usually the speaker. And I have heard on many, many occasions, we are not handwriting experts. We just can't take on that role. There's no way for us to have that kind of expertise. So we're just verifying that person is a registered voter. And we do find people that are not registered. In this particular round, we had some people that didn't live in Raleigh, but they, they're enthusiastic. And that's why we go through the list, because there was about a 10% error rate on it, which is why we told them they needed extras.
Just a quick question here.
Yeah?
So the affidavit that's been put forward is the 5 bullet items?
The affidavit is the whole page.
5 bullet items?
Well, those are the reasons for recall.
Yeah.
It's part of the affidavit.
And so the affidavit is, I'm sorry, what is it? Is this the affidavit?
No, that's a receipt.
All right, so where's the affidavit?
The page that says affidavit.
This one right here? Okay. And what was on it before?
It did not contain the word affidavit, did not
Okay.
contain the word pains and penalties.
Okay, so now there's a word affidavit added to this thing. And is there anybody signing this affidavit? Is it actually the individual voters?
Anyone who's,
I can explain.
okay.
The special act under which we're acting requires the submission of an affidavit signed by at least 100 registered voters. So every person signing that petition was now signing it as an affiant.
Okay. So now all these people are on the record as being an affiant.
That's
Am I
right.
correct by saying that? Okay.
That's right.
Okay, so now my question is, how do you get around the fact that the signatures for the recall were got before the affidavit was? I'm just kind of confused here.
I'm sorry, I can't hear the question, Tim, say it again.
The affidavit was got after the signatures were got for the major recall.
You know, this is what I was talking about earlier, that I regard the absence of the word affidavit and the words pains and penalties of perjury in the October 5th filing as a technical failure. There is nothing either in the Act or in any statute or case law that I've been able to find that says that would prevent the Board of Registrars from accepting a curative filing, that is, one that cures the defect by adding the words affidavit and signed under the pains and penalties of perjury. Clearly, you couldn't just put those words on the October 5th document. They had to go out and recollect signatures. But once that is done, then I believe very strongly that any court that reviewed this matter would determine that the cure was effective and that it would not be necessary to jettison the, was it 1,300 signatures that came later after the October 5 filing. And crucial here, too, is that no one of those 1,300-odd signatories were misled in any way by the absence from the October 5 filing of the words affidavit or pains and penalties of perjury. I would feel very differently if anybody had been actually misled into signing something they didn't want to sign. But that case can't be made here.
I disagree with that. I object to that. You may have your...
Say it again?
I'd like to get a copy of that.
Yep.
That's the only thing that's different from the stuff I got
Yep.
earlier.
I will make a copy after this hearing and
Yeah,
have it
that's
for you.
fine.
Paperwork time.
Well, I came in the office on 3 occasions, said it's a moot point because you went out, they went out and got more signatures. Okay, so they had an affidavit, they climbed that mountain and went over the top. So you cured your dilemma here. I really think it's too late for doing that. I think that I'm not going to stand for that. That's a violation of my constitution-like rights. Handwriting evidence, I didn't have to present that today. That's just there. That's in the record. Anybody who looks at that, they can, debate that if they want. The other thing that I'm taking an objection to is the using the stamp to certify the signatures. I don't believe that that is the intent of the law, to have a rubber stamp to go around and do that. The intent is to protect people's rights by, going through those signatures as a board member and certifying whether they feel that that is correct or not. And that the more eyes on something like that important about a constitutional right of some individual, especially an elected official here in town, should be not taken lightly using a rubber stamp. So, I don't think you can get around that.
Well, I think we can. I mean, we
Is there
can
any-
talk to the Secretary of State's office, who clearly,
Okay, is there any authorization that you received,
No.
Ms. Hazen, from the board members that
I
allow
believe
you to
Mr.
use
Mullen
the-
can speak to that.
Is there a written statement from them that allows you to do that?
First, as to the question of using a facsimile stamp, there's 950 CMR 55.027, which says 3 or more registrars must sign their certificate on each page. Here we're talking about pages of signatures. A facsimile stamp may be used for this purpose. And as I read earlier from a later section, the registrars may authorize the office employees of the city or town clerk's office, including the city or town clerk, to perform all of these actions. This authorization may be accomplished by, among other things, a vote of the Board of Registrars. I don't know whether there has been a vote of the Board of Registrars specifically delegating this function to the town clerk. I would say that the use of the term by, among other things, indicates that an express vote is not required. I think we've heard that here that at least since 1996, the town clerk has always done the certification on her own, and the Board of Registrars has never insisted on having a hands-on role in that process.
I would amend that to at least since 2000. The system went into effect in 1996. I can't speak to how Gene Grover certified. I just don't have that knowledge. But since 2000, I've always done it. I don't, off the top of my head, think I can point to a specific piece of paper that the Board of Registrars said, we hereby authorize you to use the facsimile stamp. However, by virtue of them supplying their signatures for the manufacturer of said facsimile stamp is some indication that they had reason to give me permission to use it. We've been doing this for 15 years. So they certainly, if there was an objection on the part of the Board of Registrars, we would have heard that at any point prior to this.
My constitutional rights are on the line here, and you're telling me that there's nothing in writing that authorizes you to use a rubber stamp to certify what these gentlemen
I'm saying
ladies
Massachusetts
need
law
to be looking
authorizes
at
me.
to certify things. So I'm just appalled that it just comes down to a loosey-goosey type thing here, you know? And then just because you've been doing it now for how many years? How many years have you been doing it?
15 years.
15 years. That it makes it right? There's no vote? I don't understand how you can get around this thing. I really don't.
All I can go back to is referring to the Secretary of State's office, Massachusetts law. I certify a lot as I said, there's 19 petitions out there right now for this petition season, not counting whatever is happening in the town of Rowley. And the Secretary of State's office requires that, it doesn't so much require that facsimile stamp, but it certainly accepts without hesitation that facsimile stamp. That is how it's done, and that's how it's done in every office. I happened to have occasion last night I went to a function, and I was speaking to the president of the Mass Town Clerks Association, and I told him we had this hearing today, and that the allegation was that I acted unilaterally, and asked how many town clerks brought other Board of Registrars in to certify papers. And he agreed with me that he knew of none. It's just too complicated a process to make it a four-man job. I can't describe it any other way. It'd just be chaos if you had four. The Secretary of State's office accepts that facsimile stamp, and I think that's the proof that the facsimile stamp is acceptable.
I'm not accepting it, Susan.
I understand that.
I'm not accepting it. And I'd like to just make one last comment here. I'd like to talk to the board. I think it's really up to you folks. I mean, this is the power that you've been bestowed to have. I feel it's a real big mistake that this goes forward, based on the reasons on this petition are not factual. I could understand if there was some factual nature to putting something on a petition that you couldn't get around, but this is not factual. So you're taking the word of a movement in this town, trying to remove me based on information that somebody started the ball rolling on. And it's really, it's a shame that we have one person that was the focal point of this whole movement, that he was putting this thing forward, and it's not based on fact. Do you have any questions for me? This whole thing is in your hands, you know? But I am not going to sit down, I'm not going to allow this to happen. I'm just not going to do that. So, I mean, I'm going to protect my rights as a person here in town and an elected official.
Anything else, Tim?
I would just like to know when the minutes are going to be available.
Sometime afternoon tomorrow, I would think. No, tomorrow's Saturday. I'm not sure I'm going to get the minutes done this afternoon.
Okay. So I'd like to get a copy of the minutes.
Copy of the minutes?
And also this new petition that they rushed out and
Yeah.
got to try to cure the problem. Thank you.
Speak or
No, I think you just want to ask if there's any discussion and then take a vote.
discussion of the board?
Yeah, the board.
So any discussion from the board?
There is none. They
There
were
is none.
certified correctly.
Gordon feels that they were certified correctly. Mrs. Dummer?
I do.
Mrs. Demento? Can I ask, do you feel any hesitation of use of the facsimile stamp?
Not at all.
You, Millie, and Barbara have been on the board prior to me. This has been a policy for many years.
Yes, a long time.
Do you remember doing actual paper ballot,
I do, for a few years, and then this new procedure came in, and it was, I felt very good.
Yep. So in terms of the specific complaints we have here, where do we stand? The board feels that the signatures were appropriately certified.
Absolutely.
Do we feel that, it is my personal feeling, that it's beyond the expertise of the Board of Registrars, being three citizens and a town clerk, to know the legal technicalities of what constitutes an affidavit? Would we agree with the statement that we accepted it in good faith according to the rules of the, indicated in the Recall Act?
Absolutely. No.
So we accepted bylaw, we accepted, my apologies, affidavit number 1, in all good faith, as a will of the public of the 100 signatures that we certified. So we say we can't speak to whether or not it's an affidavit. It's just beyond our technical expertise. As I mentioned to Mr. Toomey, it's not part of the complaints, but we are not commenting at all on the pros and cons of whatever the reasons for the recall are. That's not what we're here for. That's not what we're doing. We're only certifying the signatures.
That's it.
Not properly submitted to the Board of Registrars. As I said, I will take the hit for that. That is just a technical error. I forgot to stamp the bottom of the page. Entirely my fault, not their fault. I don't know, forgot to stamp the bottom of the page. In terms of the second objection, how do you feel about the allegation that the signatures on the recall petitions were suspect and that many of the signatures are in the same handwriting? I will point out that the registrars have in their packet a complete copy of Affidavit 1 and a complete copy of Affidavit 2, so they can read the signatures as they're sitting. They were also mailed that copy, so they all said to me they had read all the material from start to finish at home, so they're not looking at it for the first time today.
That's correct.
Any thoughts on that?
No,
I looked at every one.
Gordon said, I looked at everyone.
Well, I'm sure the ladies did too. so-
I will point out, all 100 of those first signatures, the names are reflected on the initiative petition. We had to write all 100 names on it. No one came to us and said, I didn't sign that. That's kind of significant, I think, in that certainly is out in the public. It's not like we're keeping those signatures a secret. We had to list those first 100 names. And so 1,303 people held that petition in their hand with those 100 names listed, and no one came to us and said, I object, I did not sign my name, which would be a concern for us, but we have not heard that. So you're comfortable that the signatures are
I am.
adequate to the best of our
Yeah.
ability?
Anybody who looked at that could just tell they're all different.
They're all different.
Yeah. They're just,
I also think, in
some I
looking at them,
recognize, these people I know.
there was a printed name, and there was an address, and then the signature, or maybe sometimes it's in different order. And I do think sometimes the printed name are the same. I think, I don't know, maybe husbands let their wives do all the paperwork, all right, but sign this. Do you know what I'm saying? I did see that many times. The printed name was suspiciously similar. That's not what we're certifying. That the recall petitions were submitted to the Board of Certification and that the town clerk acted unilaterally to certify the signatures. Again, we spoke to that a minute ago, that the board is comfortable that this is a practice that they approve of, have no qualms about it, and have no problem with the use of the affidavit stamp.
Sure.
Number 3, the letter filed by Ms. Lavasser was not an affidavit. We spoke to that as number 1 of the November 9th objection. Number 4, the affidavit was never made by an affiant under the oath or affirmation administered by a person authorized to do so by law. We spoke to that under number 2 of the November 9th affidavit. And 5, the signatures filed since October 5th, 2015 with the town clerk's office were never properly submitted to the Board of Registrars for certification, and we spoke to that under number 3 of the November 3rd affidavit. Let me say it again, November 9th objection. So hearing that, what do we want to do? Do we want to move forward? I would move to hear a motion that the town of Raleigh reject the objections filed by Timothy Toomey in his complaints of November 9th and November 10th, 2015.
I so move.
Yes? Do I have a second?
Yes.
Yes, can I have Gordon and Millie sign that? Motion by Mr. Densmore, seconded by Mrs. Demmer. No, I don't need Barbara's, I just need to. Thank you. So, all in favor, say aye.
Aye.
Yes, Barbara?
Yes.
I need to hear it. Aye. Thank you. Any opposed? We have unanimous to reject the objections. Unanimous. I'm writing down the time because I do town clerk, town meeting, and it requires the time. This probably doesn't, but it does have that. So we haven't rejected the objections because the Board of Registrars is comfortable with the way it was done, feel it was done appropriately and in compliance with the act as they read it. And we feel as though deciding about the affidavit may be beyond our scope of expertise and maybe for another arena. Our second item on our agenda is to submit to the Board of Selectmen a letter calling for them to go to the next process, which means we've accepted the signatures of the 1,303 signers of the initiative petition for the recall, and the next item says, now that we've got through the first sentence, the town clerk shall deliver to said voters making the affidavit copies of petition blanks demanding such recall. They shall be dated, shall be addressed to the Board of Selectmen, shall contain the names of all the persons to whom they issued the names of the person whose recall is sought and the grounds for such recall, and shall demand the election of successor to said office. Such recall should be returned to the town clerk. We've all done that. Contain 25% of the registered voters. The town clerk shall, within 72 hours of receipt, submit the petition to the registrar of voters, and the registrar shall certify. If the petition is found and certified by the town clerk to be sufficient, he shall, without delay and forthwith, I've always loved those, give written notice to the receipt of the certificate to the Board of Selectmen, and they will move on to the next step. So with that being said, I have a letter printed up here. Dear Raleigh Board of Selectmen, attention G. Robert Mary, Chairman, regarding recall petition against Timothy Toomey. Dear Sir, upon receipt of the signatures of at least 100 registered voters from the town of Raleigh, recall petitions were issued on October 16th to Ms. Mary Ann Lavasser towards the recall of Water Commissioner Tim Toomey. At that time, Town Clerk Susan Hazen issued a receipt certifying the number of registered voters as of 4:30 on Thursday, October 15th, to be 4,442, thereby making the minimum number of signatures required to be collected to be 1,111. We, the Raleigh Board of Registrars, do hereby certify that the 1,303 signatures certified on the recall petition exceed the required 25% of registered voters currently listed on our voters list, and ask the Board of Selectmen to proceed with the recall procedures according to legislation entitled Recall Election, Chapter 637, Commonwealth of Massachusetts, 1989, an act providing of recall elections in the town of Raleigh as found on pages 55 and 56 in our general bylaws. Are you ready to sign that letter? And
Ready.
do we need a motion to accept that letter, or is that by virtue of?
No?
Can I have a motion to accept this letter?
Make a motion to
and sign
accept
it?
that letter to the Board of Selectmen.
Motion. I didn't write that one up ahead of time, so I took time
Right.
to accept letter as read
Yeah, to the Board of Selectmen,
and submit to the Board of Selectmen.
relative to Recall.
That's sufficient? All in favor?
Aye.
All in favor. Could I have your signatures? And your, Barbara gets to sign this time.
Madam Chair, can I suggest one further motion? Since your authority to certify signatures on behalf of the Board of Registrars has been called into question, I'd suggest you entertain a motion to ratify your authority to do so in this case, and specifically to authorize you to do so in all cases in the future.
So we're going to, looking for a motion to give the town clerk or the town clerk's office
Clerk.
authority for use of the facsimile stamp.
To certify signatures and to use the facsimile stamp.
Signatures, we don't need any further description of petitions, nomination papers, and use of facsimile stamp. Facsimile stamp. So I'd entertain a motion.
Oh, excuse me, and specifically to ratify your use here.
Oh, all right. So we're not moving forward, we're looking to ratify,
Both.
okay, and to ratify. Ratify, is that what you want to say, use here, or?
And to ratify the town clerk's certification of the signatures in this case.
All right. So now I have a motion to give the town clerk authority to certify signatures and the use of the facsimile stamp, and to further ratify the town clerk's certification of signatures in this case. Can I have a motion?
So moved.
Gordon, seconded? They speak so softly. Millie, seconded? And I'll ask for your signatures. All in favor?
Aye.
Any opposed? No? I will write that up and ask for your signatures
Sounds good.
on a better piece of paper, but if you could just
Yeah.
jot your signature, your initials down there. Do we feel as though we've covered everything that we needed to cover in this hearing? Yes? Hearing no further business, I declare this hearing closed. Yes? He looked like he was going to say more. I thank you all for your kind attention, and thank you.